Good afternoon, everybody. Welcome to the Tom Lantos Human Rights Commission hearing on corruption and human rights, improving accountability. I will introduce our witnesses in a few minutes, but I would like to thank them now for taking the time to be with us today. As you may know, the U.S. State Department plays a primary role in developing foreign policy responses to address international corruption. We invited the State Department to testify at this hearing, but the invitation was declined yesterday. I regret that we will not be hearing from State on an important problem identified both in the 2015 National Security Strategy and the Quadrennial Diplomacy and Developmental Review. I was especially looking forward to hearing from State how Secretary Kerry viewed U.S. participation and outcomes from the Global Anti-Corruption Summit that happened last month in the UK. However, since State is not here, we will be sending the Secretary many written questions, and we will make his responses publicly available, and we look forward to those responses, hopefully in an expeditious manner. We have known that international corruption is a problem for a long time. Back in 1977, the Congress passed the Foreign Corrupt Practices Act, which prohibits the bribery of foreign officials. More recently, U.S. anti-corruption efforts are focusing on grand corruption and kleptocracy, an extreme form of high-level public corruption that often involves state capture by business elites or state predation by corrupt actors. This commission is interested in corruption because it is widely acknowledged to be linked to human rights abuses. Corruption can reduce the political will of a government to respect, protect, and fulfill human rights obligations, as well as the financial capacity of a government to provide basic services and welfare to its citizens. It can weaken government accountability and transparency and facilitate the hold on power by authoritarian actors. There are plenty of examples of this. When a judge accepts a bribe to alter a court decision that deprives someone of the right to a fair trial, offering basic services such as medical treatment or access to water on the basis of bribe payments discriminates against non-bribe payers and deprives them of the right to those services. When public funds destined for these same services disappear into the pockets of officials, the funding for them simply disappears. When officials accept bribes to import toxic waste or to grease the illegal passage of human trafficking victims across borders, at a minimum, they are facilitating human rights violations. And when corrupt acts by government officials and elites are committed with impunity, then the rule of law is degraded for all. We can see the correlation between international corruption, human rights, and development just by comparing where countries fall on some of the well-known indices. In 2015, none of Transparency International's most corrupt countries were considered free by Freedom House, and most were categorized as having low or medium human development on the UN Development Programme's Human Development Index. Under both Presidents George W. Bush and Obama, the U.S. developed strategies to fight corruption and kleptocracy. The Obama administration announced additional anti-corruption commitments related to financial transparency, following release of the so-called Panama Papers in April of 2016. The questions that concern us today are whether we're doing enough and whether what we're doing adequately addresses the relationship between corruption and human rights. As I mentioned earlier, last month, Prime Minister Cameron of the United Kingdom hosted the International Anti-Corruption 2016 Summit. More than 40 countries, including the United States, attended. The final 9-page communique emphasizes enhancing transparency, which is certainly appropriate, and includes a section on punishing the corrupt by ensuring and enforcing domestic laws and increasing international cooperation around their pursuit. The communique highlights some measures I have supported for a long time, making it harder for those who are corrupt to travel and do business in our country. So all this sounds good. But the communique is also notable for what is not emphasized. Human rights is mentioned exactly twice. First, to note that tackling corruption is vital for protecting human rights, and second, to say that the improvement of enforcement capabilities will be undertaken while respecting human rights. Meanwhile, the topic of corruption in sports merited 2 full paragraphs. The summit recognized that people should be able to report corruption without fear of reprisal, and there are references to protecting whistleblowers. But there's nothing explicit about the risk of physical attack, imprisonment, or even death that people who expose corruption face. The communique mentions supporting those who have suffered from corruption, with a lot of attention on asset recovery. This is fine as far as it goes, but what principles should govern the use of recovered assets? Where corruption is linked to human rights violations, where is the commitment to use assets for reparations for the victims? Where would the sacrifice of Sergei Magnitsky be if Congress had not recognized his fight against corruption in Russia? What about the heroic efforts of civil society in Guatemala and Honduras to challenge decades, even centuries of corruption by officials and elites in these two countries? Finally, there is no reference in the communique to prosecution at the international level of those responsible for corruption. It seems to me that the option of international prosecution, especially for kleptocrats, should be on the table. I'm glad to see corruption and its consequences receiving more attention. Just this week, the OECD and the International Bar Association are holding anti-corruption conferences in Paris. But I'm concerned that despite the linkages between human rights and corruption, policy efforts to address these two issues are running on distinctly separate tracks. International anti-corruption commitments, including those just made at the London summit, do not reference international human rights instruments. Yet regimes that commit human rights violations with impunity also commit corruption with impunity. Better said, impunity facilitates both human rights violations and corruption, and improving accountability is key to ending both human rights abuses and grand corruption. So I look forward to hearing today from our witnesses about what has been achieved in the fight against corruption, including their views on the London summit. I'm also eager to hear their recommendations for what more is needed to ensure accountability, especially for public officials who are responsible for grand corruption. And I'm also interested in hearing any suggestions for Congress and for those of us who are concerned about this issue, concrete steps that we might consider taking in the coming weeks and months. So with that, I want to welcome our panel of witnesses. I'm going to introduce them in the order in which they are speaking. Mr. John Sifton, welcome back. He's been before our committee for, I think this is the third time in 2 weeks. Yeah. But he is the Deputy Washington Director for Human Rights Watch and works on South and Southeast Asia. Previously, he was the Director of One World Research and also worked for the International Rescue Committee, primarily in Afghanistan and Pakistan. And in 1999, he worked at a refugee advocacy organization in Albania and Kosovo. He holds a law degree from New York University and a bachelor's degree from St. John's College in Annapolis. Ms. Stephanie Ostfeld is the acting head of Global Witness's U.S. office. Global Witness is an international advocacy organization that works to break the links between natural resource exploitation and conflict and corruption. Based in Washington, D.C., she advocates for increased corporate transparency, closing loopholes in anti-money laundering laws, effective enforcement of anti-bribery and anti-money laundering statutes, and revenue transparency in the oil, gas, and mining sector. She holds a MA in International Human Rights from the University of Denver, Joseph Corbell School of International Studies. Mr. Matthew Murray served as legislative assistant for national security to Senator Edward Kennedy, and was an associate attorney at Baker & McKenzie, where he helped the firm launch a Russia law practice. In 1991, he founded Sovereign Ventures, Inc., a management consultancy firm that advised on how to reduce corruption risk and engage in dispute resolution. In 2000, Mr. Murray co-founded the Center for Business Ethics and Corporate Governance, a nonprofit dedicated to building rule-based markets in Russia, Central Asia, and Eastern Europe. In 2011, he was invited by the Brookings Institution to help launch the World Forum on Governance and co-write a research paper entitled Freedom from Official Corruption as a Human Right. He will discuss that research today. Mr. Murray holds a master's from SIPA and JD from the law school, right? Did I say that right? Yeah. In Columbia, all right. Columbia, right? All right, that was missing here, but I knew there was something missing. But a very, very smart person. Yeah, and finally, the Honorable Mark L. Wolf was appointed to the United States District Court for the District of Massachusetts in 1985, served as its chief judge from 2006 through 2012, and is now a senior judge. He has previously served in the Department of Justice as a special assistant to the Deputy Attorney General of the United States, and the Attorney General of the United States, and as Deputy United States Attorney for the District of Massachusetts and Chief of the Public Corruption Unit in that office. He was also in private practice in Washington, D.C. and in Boston. Judge Wolf is the chair of Integrity Initiatives International, and it is in that capacity that he is testifying today. Judge Wolf is a graduate of Yale College and the Harvard Law School, and the Harvard Law School, and I should say for the audience here that I think what kind of sparked my interest in this was, was Judge Wolf, who has talked to me extensively about this issue and about some of his ideas, which we will explore when he testifies. So everybody can submit their formal testimony for the record without objection, and at this point we'll begin with Mr. Sifton, and we welcome you all here.
Thank you. And I'd like to start my testimony with a quick tribute to a Minister of Parliament who was brutally killed today in the United Kingdom. Jo Cox was a longtime human rights advocate with Oxfam. She was also, as a Minister of Parliament, a campaigner against corruption, and as recently as last month had urged David Cameron, both in Parliament and in the newspapers, to do more to rein in the excessive secrecy for British tax havens. And it was a tremendous friend of many Human Rights Watch staff. I only had the privilege of meeting her on one occasion, but many of HRW's staff are devastated today. Thanks for this opportunity to speak about the linkage between grain corruption and human rights. The issue really, unfortunately, is a persistent one. Human Rights Watch has now been working on the connections between grain corruption and human rights for almost 20 years. And the reason we work on corruption is because we know it's one of the key drivers of human rights abuses. Mismanagement and corruption fuels human rights abuses in numerous ways, and my written testimony, reviews them. The main way is that grain corruption deprives government treasuries and coffers of billions of dollars that could be used for public services in health, education, and key social areas. As you know, the economic, social, and cultural rights are a progressive realization scheme where the states are given an opportunity to progressively realize rights to education, health, and other basic services. And the more money they have, the more is expected of them. Corruption essentially robs them of that capacity. I review a couple of examples in my written testimony from Angola, for instance, where almost 10% of the GDP disappeared at one point in the last decade, and a little bit later, it was documented that another 41 billion had disappeared in subsequent years. Nigeria's Niger Delta, we've have research showing loss of local government revenues to corruption and mismanagement, and how it's contributed to the woefully inadequate health and education services. Corruption also leads to violations of the right to free expression and free assembly. Governments withhold information from the public, and they crack down on journalists and civil society who try to expose their mismanagement and their corruption. And this is probably where we, as an organization that focuses more on civil and political rights typically than economic and social rights, this is where we document the biggest problems. So recently in Malaysia, for instance, we've seen Prime Minister Najib Razak implicated in an enormous scandal involving his country's sovereign wealth fund. And he was already cracking down on opposition and dissent before this scandal broke, but since he's been using the defamation and sedition laws and other attempts to basically shut down any media outlet or blogger or any dissenting voice who is attempting to expose, write about, elucidate the massive corruption scandal which is threatening him. In Angola, where I just mentioned, there's continual problems with the government cracking down on journalists who are trying to expose corruption. Rafael Marquis, who's an internationally recognized Angolan journalist who runs the anti-corruption blog Maca Angola, has been repeatedly harassed by authorities, arrested, and it continues to face all kinds of legal problems. But I want to use the bulk of my time left to talk about Azerbaijan, which is the home to billions and billions of dollars in natural gas reserves. The Panama Papers, we already knew how corrupt the regime was, but the Panama Papers really brought home the dramatic scale of the corruption. They've exposed evidence indicating that that Aliyev's family, the President Aliyev's family, has extensive secret offshore accounts with all kinds of business interests, including in gold mining. Azerbaijan's government has essentially been waging a repressive campaign against anybody who's been attempting to expose their corruption for the last few years. And this has led to dozens of journalists and human rights advocates being locked up. Now, more recently, a couple of them have been released, which is good news. And we hailed that. But the fact of the matter is, Azerbaijan remains a place where if you attempt to expose the corruption of the regime, you are at great risk of being arrested and thrown in jail on spurious charges. It also, though, gives an example of what happens when governments stand up and demand that governments like Azerbaijan's not crack down. The reason so many dozens of activists have been released in Azerbaijan in recent weeks and months is because of the pressure that's been put on them by governments like ours, the United Kingdoms, and others. The combination of grand corruption and unaccountable governments is a serious threat to human rights worldwide. And it should come as no surprise that in Angola, Azerbaijan, China, and many other countries, unaccountable leaders are implicated in corruption, and their leaders face constant human rights challenges. It's no surprise. Corruption entrenches and enriches autocrats while corroding government institutions. My written testimony elucidates on how the U.S. government can better attack this problem. And you've listed some of the things that have happened in the past. I'm proud to say that my late father, who's also a federal judge, worked on the Foreign Corrupt Practices Act when he worked for Senator Fulbright way back in the old days, over 50 years ago. But the efforts have to continue today in new and creative ways. Judge Wolf is going to talk about the proposal for the International Corruption Court. In my written testimony, I basically endorse it, this proposal. Human Rights Watch believes the International Corruption Court, which I'm not going to talk about because I think it's much better for other panelists to talk about, could be a valuable step forward. But there are other key challenges, which I've outlined at the very end of my testimony. Ensuring that the U.S. government anti-kleptocracy initiatives are sufficiently resourced, so in other words, paying for them. Implementing new measures to stop corrupt officials from spending their illicit funds in the U.S. That includes legislation that would require disclosure of beneficial owners and addressing shell companies. I think David Cameron, was disappointing in London during that conference, but it's also true, as The Economist recently pointed out, that the U.S. has a lot to answer for, too, for its state corporate laws in places like Delaware. There's other things about pressing the World Bank that are in my testimony about the Stolen Asset Recovery Initiative, as you say, we admit without objection. If these measures are undertaken together with the other proposals that are going to be put forward today, then the prospects for an international court will actually grow because more governments will be taking more steps to root out kleptocracy. And just as the U.S. set an example way back in the 1970s with the Foreign Corrupt Practices Act and paved the way for other nations to enact anti-bribery legislation, the U.S. can enhance its leadership today by strengthening its own anti-kleptocracy efforts at a domestic level. So that's the gist of it. I'll leave it there, and I look forward to questions.
Thank you, Ms. Ostfeld.
Good afternoon, Co-Chairman McGovern. Thank you for this opportunity to appear before the Commission to discuss corruption and human rights. Global Witness participated in the Anti-Corruption Summit recently hosted by the UK, and we're delighted to have the opportunity to share with you some of our proposals for curbing corruption and protecting human rights. So Global Witness has offices in Washington, D.C. and London, and for over 2 decades, our hard-hitting reports and investigations.
Is your mic on? Just make it should light up, yeah.
Can you hear? Is it better now? How about now? Okay. So Global Witness is an NGO with offices in Washington, D.C. and London. For more than 2 decades, our hard-hitting reports and investigations have exposed how timber, diamonds, minerals, oil, and other natural resources have incentivized corruption, destabilized governments, and led to war. In our work around the world, we see the same problem all the time. Fledgling economies stifled and ordinary people trampled by corrupt regimes that rule with one iron fist and steal with the other. To some, corruption may appear a victimless crime, or just the way business is done, but it is a key reason why so many of the world's poorest, most oppressive countries remain that way. Take the fragile political transition in Burma, for instance. Global Witness has estimated that jade production in 2014 alone generated the equivalent of nearly half of the country's GDP, with the major benefits going to some of the most notorious names from the military junta era. This provides tremendous resources to those most likely to oppose reform by Burma's new civilian-led government. But corruption isn't something that just happens over there. Corruption on the scale that we see in our investigations could not happen without the actions of global facilitators. The corrupt need a bank willing to handle money without asking questions, or a lawyer to work out how to skirt laws and disguise their identity. Time and again, our investigations highlight the same problem, and that's sham companies which allow those who steal state funds to move it undetected through the international financial system. This is what we're trying to change. So take Nigeria. In 2011, Royal Dutch Shell and the Italian oil company Eni paid more than $1 billion for one of West Africa's largest offshore oil fields. The payment was equivalent to 80% of Nigeria's proposed 2015 health budget, but the money didn't end up in state coffers. Instead, it went to a front company owned by the former Nigerian oil minister who had granted his own company rights to the oil field back in 1998. Now, Shell and Eni have always denied they knew their payment would be going into private pockets, but evidence gathered by Global Witness and our partners shows otherwise. Matters are now coming to a head. Eni's current and former CEOs are under investigation in Italy, while Shell's headquarters in Holland were recently raided by 50 police officers. The case should put decision makers and investors on notice. Laws have been enacted in the US and EU which will require extractive companies to declare the payments they make to foreign governments. If properly implemented, these new laws would provide real legal, reputational, and financial consequences, and hopefully relegate this type of behavior to the past. But the secret companies at the heart of this deal also need to be a thing of the past. The Panama Papers have shown the world how deep a problem it is, but this isn't a new problem. The World Bank found that opaque company structures were used in at least 70% of the grand corruption cases they looked at over a 30-year period. And contrary to the common misperception that this type of secrecy is mainly provided by sunny tax havens in the Caribbean, the US is actually the heart of the problem. A separate academic study from 2014 found that many US states are among the easiest jurisdictions in the world to set up an untraceable company, even for inquiries that sounded like a clear front for terrorism or that should have raised a corruption red flag. So in January, Global Witness published an undercover investigation into the role of anonymously owned companies in money laundering. You may have seen it on 60 Minutes. We sent an undercover investigator into 13 New York law firms. He posed as an advisor to an unnamed African minister of mines who wanted to secretly bring suspect funds into the United States to buy a mansion, a yacht, and a private jet. And the results were shocking. 12 of the 13 lawyers provided suggestions about how to move the money using anonymous shell companies and trusts, and 11 of them suggested using American shell companies as part of the structure to hide the fictitious minister's identity. Now, many of the lawyers indicated they would have to do further checks before agreeing to take our investigator on as a client. No money was exchanged, and nobody broke the law. But what is really remarkable about our findings is how consistent the lawyers' suggestions were during the meetings with our investigator. It goes to show you this is how it's done, and that it's far too easy for corrupt officials and other crooks to hide behind the secrecy of anonymously owned companies. But there's hope. The U.S. has long led the world in the fight against global corruption. We were the first country to adopt anti-bribery legislation, and we've seen leadership from both sides of the aisle, with Presidents Bush and Obama each championing measures to curb corruption. And last month at the UK's Anti-Corruption Summit, the US and our closest allied governments clearly acknowledged the damage done by corruption and the threat it poses. So we were happy to see heads of state and senior politicians agree to strong new measures, including company ownership transparency, open contracting, and better cooperation to track down and return stolen funds. Congress has a really important role to play, and we encourage you to pass two bipartisan measures. Now, the first is the Incorporation Transparency in Law Enforcement Assistance Act, which is H.R. 4450, introduced by Representatives Peter King and Carolyn Maloney. It would end hidden company ownership and prevent corrupt money from entering the United States. And the second is the Global Magnitsky Human Rights Accountability Act, H.R. 624, introduced by Representative Chris Smith and co-sponsored by the co-chair. It would deny human rights violators and the corrupt entry to the U.S. and access to U.S. property transactions. And we also support 5 additional recommendations. The first is to increase transparency in the contracting process among legal entities that receive federal funds. The second is to implement beneficial ownership transparency requirements for real estate, escrow agents, and luxury goods. The third is to increase resources for law enforcement cooperation to fight corruption. Fourth is to make the transparent and responsible management of natural resources an integral part of U.S. foreign policy objectives. And finally, to protect human rights and support civil society in holding governments to account for governance of the natural resources sector. Thank you for inviting Global Witness to testify today. We look forward to working with you and your colleagues to identify ways to prevent the U.S. from enabling corruption and to hold individuals and companies accountable for their actions. We're pleased the UK Anti-Corruption Summit brought us closer to transforming corruption into a mainstream issue, and that Congress is continuing the momentum by hosting this important hearing. I look forward to your questions.
Well, thank you very much. And I did see that 60 Minutes show, by the way. It was outrageous. But Mr. Murray?
Thank you, Mr. Chairman. It is my distinct honor to participate in this hearing today and to have an opportunity to discuss how to improve accountability for corruption and human rights. It is a privilege to be a member of this esteemed panel of experts. And I also want to thank my colleague, Andrew Spalding from the University of Virginia Law School, with whom I have been conducting research of the ideas that I would like to present to you today. As you know, both corruption and human rights are matters of increasing global concern, and both are subjects of international law. It has long been agreed that no single nation can either uphold human rights or fight corruption effectively without the cooperation and support of other nations. Under prevailing international law, many nations have signed and are obligated to implement treaties and conventions, both to protect human rights and to criminalize acts of official corruption. Yet, the anti-corruption architecture is not working as planned, whether to assure effective enforcement or protect the victims. And there is increasing concern that official corruption provides both the incentive and means to violate human rights. The abuse of public office for private gain, as corruption is now defined, often results in patterns of repeated violations of human rights, as you have elucidated and as the witnesses have testified to. Mr. Chairman, the challenge that you and the Human Rights Commission pose today, how to strengthen accountability for corruption and human rights, raises a fundamental question of whether and how international law links these two goals effectively. And my goal today is to identify what you might deem a gap in the architecture on this subject. And I will make the case further that in order to increase accountability for both corruption and human rights, we must first place anti-corruption norms on a new footing, on a stronger conceptual foundation, and elevate enforcement as a matter of public policy, and focus enforcement on improving the lives of corruption's victims. I will present the case that in order to fill this accountability gap, freedom from official corruption should in fact be established as a fundamental and inalienable human right. First, let me describe for a minute what is the current interplay of these two areas of law. As a starting premise, we know that the global community has recognized corruption involving public officials as a principal cause of human suffering, of deprivation, but not as a violation of human rights. The major rights conventions, including the United Nations Universal Declaration of Human Rights and regional conventions that have been adopted in Europe, the Americas, Africa, and Asia, do not include freedom from corruption among their enumerated rights. In addition, the prevalent international anti-corruption agreements, such as the United Nations Convention Against Corruption and the OECD's Anti-Bribery Convention, do not frame official corruption as a rights violation. Mr. Chairman, instead, as you and the witnesses have pointed out today, official corruption is typically understood as a means by which other established human rights are violated. As stated by former head of the United Nations, Kofi Annan, in the foreword to the United Nations Convention Against Corruption, corruption is an insidious plague that has a wide range of corrosive effects on societies. It undermines democracy and the rule of law, leads to violations of human rights, distorts markets, erodes the quality of life, and allows organized crime, terrorism, and other threats to human security to flourish. When adopted in 2005, the United Nations Convention Against Corruption actually went well beyond previous international agreements to require signatories to criminalize money laundering, embezzlement, and other forms of corruption. But it did not embrace corruption, freedom from corruption as a human right. In the meantime, to facilitate political freedom and economic development, both the United Nations and regional and multilateral bodies have established a range of other human rights, including first-generation civil and political rights, such as freedom of speech and religion, to second-generation economic and social rights, such as the right to property, education, and health, and beyond. And these bodies seek to uphold these rights by, among other things, requiring governments to adopt and enforce laws that prohibit corruption. They have not, again, however, recognized freedom from corruption itself as a human right. In my view, and in the view of my colleague Andy Spalding, there's a strong case that freedom from corruption is an inalienable universal right belonging to all humans. Though current international treaties do not recognize the right, legal philosophers have long acknowledged that these instruments are but one of several bases for making a rights argument. There are three legal lines of reasoning that argue for considering the creation of a standalone right. First, and historically the most foundational, is natural law, particularly the writings of John Locke. And though Locke did not use the term corruption, his concern with protecting citizens from the abuse of public office pervaded his rights theory. What Locke calls liberty is to have a standing rule to live by, common to everyone of that society, and made by the legislative power, not to be subject to the inconstant, uncertain, unknown, arbitrary will of another man. That is, our natural right to liberty can only exist where government exists, and its officials do not abuse their public office for private gain, where they do not act corruptly, in other words. So Locke defines tyranny as, quote, making use of the power anyone has in his hands, not for the good of those who are under it, for his own private gain and separate advantage. When he does that, he is describing today what we call official corruption. Now, this distinctly Anglo-American tradition could not provide the basis, the sole basis anyways, for a universal human right. Thus, a second line of argument, which is very promising as a basis for identifying the existence of a human right, is cross-cultural research that discovers fundamental values shared by all cultures, or what are called cross-cultural universals. In our research, we have discovered that in such diverse traditions as East Asian Confucianism and Middle Eastern Islamic law, freedom from corruption is actually deemed a first principle of good governance. And indeed, it may be one of the various candidates for a universal moral principle, one that all persons have by virtue of being human and can agree to. So picture, as you may, all the disagreements that have ensued over other rights which are sometimes deemed to be Western, informed mainly by Western liberalism. And picture a discussion among people represent these other traditions and Western liberals, and I think what you would find is the compelling level of agreement that no one really should be allowed to steal from citizens if they're acting in a public capacity. And then finally, a third line of argument is that despite controversy, the international rights regime has formed a human right to enjoy possession of one's property. Though this right stems in part from Western philosophy, including Locke's right to liberty, it has increasingly been embraced as an international norm, starting with the Universal Declaration of Human Rights in 1948. A right to property has since been adopted in one form or another in the human rights agreements of the regions of Europe, Africa, and the Americas. Generally, the right is not absolute, and the state has a right to limit it, but it entitles individuals to private property and provides certain protections. And so a good example of this is that in 1952, after much debate, the Council of Europe amended the European Convention on Human Rights to provide for the peaceful enjoyment of one's possessions under Protocol 1, Article 1. The European Court of Human Rights, which is one of the most active international bodies that actually hears cases on human rights, has since adjudicated thousands of individual claims against national governments under Protocol 1, and a careful reading of these cases will reveal that many of these property cases are actually cases of corruption, where property is being expropriated or extorted by a government official, and the citizen is bringing a claim at the ECHR to recover the property. So, in summary, I think that this is a way to focus more attention on filling this accountability gap. A rights paradigm could increase political will to take the difficult steps required by both government and by citizens to counter corruption. Deeming corruption a rights violation gives international and domestic laws greater normative weight, heightening their importance in public policy. Rights violations have long been understood as more egregious and a higher enforcement priority than torts or even crimes. And so rights violations are more resistant to trade-offs, or as the prominent legal philosopher Ronald Dworkin famously said, rights are trumps. So acknowledging a universal human right to be free from corruption could effectively counter the most oft-heard objection to international anti-corruption initiatives, that corruption is somehow cultural. It could provide a basis for all citizens to bring corruption cases, not only in their own countries, but in international tribunals that could be established in the future to adjudicate these issues, such as special tribunals that are being set up in various countries to hear and adjudicate cases of corruption. I will submit the remainder of my statement for the record, and again, I appreciate the opportunity to speak to you and present this case today.
Oh, thank you very much. And Judge Wolf?
Congressman McGovern, thank you very much, not just for this opportunity to speak again before the Lantos Human Rights Commission, but for your kind words of how I've encouraged your interest in this area. We're both...
Wouldn't be here if it wasn't for you. I just want you to know that. And, so this is what has kind of raised this issue in this commission, but, and also I appreciate all the work of this panel. I said at the beginning, I mean it. I mean, all of you have really done incredible work in this area, and if I somehow had a magic wand to advise the president, I would say that you ought to get Justice, Treasury, State together and bring a group of you together to help advise them on how they can beef up their anti-corruption laws and how they can be more effective in fighting corruption, because the more you look into this, the more you see how it is related to all these other terrible things, from oppression to wars to you name it. So we need to figure out, after Judge Wills testifies, as how we can elevate this thing a little bit more. But let the judge, I didn't mean to interrupt you.
Well, you interrupted me as I was about to compliment you. So hopefully you'll regret it even more. But you and I are both from Massachusetts. As you know, across from the State House is the Robert Gould Shaw Memorial, a magnificent sculpture by St. Gaudens. And in inaugurating that sculpture, William James actually talked about corruption. And he talked about the bravery of those. Shaw, of course, led the 54th Regiment, the white Brahmin officer with the black soldiers memorialized popularly in the movie Glory. But William James spoke, and he said, of the 500 who would have the courage to storm the barricades, not one would have the lonely kind of courage necessary to confront an enthroned abuse. And I think perhaps at times you felt lonely, perhaps at times I felt lonely. I think you and I in the last couple of years have had the great good fortune to be lonely together, and we're a lot less lonely, as I'll discuss in these remarks, and as the other participants today exemplify. The Lantos Human Rights Commission has been at the vanguard in recognizing the integral relationship between grand corruption, the abuse of public office for private gain by a nation's leaders, the most egregious violations of human rights, and also the necessity to find a way to use the criminal law to punish and then deter the perpetrators of both grand corruption and egregious violations of human rights. There is a tremendous, as I'll describe, implementation gap. In saying that, as some of my colleagues today have said, that corruption is not a victimless crime, in this room I'm preaching to the choir, but it's worth noting that these are not idiosyncratic views that you and I and the other speakers today share. Several years ago, in 2013, the then United Nations High Commissioner for Human Rights, Navi Pillay, said that corruption kills. The money stolen through corruption every year is enough to feed the world's hungry 80 times over. Corruption denies them their right to food and, in some cases, their right to life. There are many other examples of how corruption has fatal consequences. In 2014, in Sierra Leone, audits found that 1/3 of the funds that were to be dedicated to combating the scourge, the urgent scourge of Ebola, could not be accounted for, but they did find some of those funds going to the health officials who were supposed to be administering them. And the auditors expressed the understandable, obvious concern that this may have caused the unnecessary loss of life. Mr. Sifton mentioned Angola. Angola has, Nicholas Kristof wrote a series of columns a year ago, I think, on Angola, and explained how it's an incredibly wealthy country with diamonds and oil and other riches. It's first in the world in the rate at which its children do not live to the age of 5. But the president's daughter, Isabel dos Santos, is reliably reported to be worth $3 billion. So this, as we all know, grand corruption is not a victimless crime. It exists because of the culture of impunity in many countries throughout the world, where the kleptocratic rulers do not fear prosecution or punishment because they control the police, they control the prosecutors, and as a judge, I say with particular regret, they direct the courts. And they're not going to permit the administration of justice to prosecute and punish their colleagues, their families, their friends
or often indeed themselves. When this grand corruption causes irreparable harm to human rights, harm that cannot be repaired after the fact. If a child starves to death, nothing can compensate for that. If a child doesn't get education, their right to life, liberty, and the pursuit of happiness is injured forever. If any person dies from a lack of medical care, that's a form of irreparable harm. And as has been mentioned several times, the corrupt governments perpetuate themselves, corrupt leaders perpetuate themselves by not permitting free speech, for not permitting the operation of true democracy, and the human rights of free expression and self-governance are denied. As I said, these irreparable harms cannot be dealt with adequately after the fact. They have to be deterred and diminished by the credible threat of prosecution. Matthew, last time I sat with my friend Matthew Murray was at the London summit. We were both there last month, and I think when I say we're getting less lonely, I think the summit did reflect an increasing international understanding that grand corruption, human rights, and world peace and security are integrally linked. The Department of State's not here today, but Secretary Kerry spoke to this at the summit. In his opening remarks, he noted that 2 billion children under age 15 need to go to schools, which in many countries will not be built because of the, quote, criminal syndicates, end quote, and the, quote, supposed leaders of nations, end quote, who are stealing billions of dollars and laundering them throughout the world. Secretary Kerry went on to say other things that are pertinent for our purposes today. He said that the quality of governance is no longer a domestic concern. Rather, it is everybody's responsibility to hold perpetrators accountable. The summit involved certain declared commitments. The summit declaration pledged the 40 nations who were there to pursue and punish perpetrators of grand corruption. And it noted that this is vital to protecting human rights. It also urged nations, I think implicitly recognizing the inadequacy of even the energetic efforts that so many individuals and institutions are engaged in. It urged exploration of innovative solutions to these problems. The summit focused, particularly in its communique, on certain action items: improving the transparency of beneficial ownership, improving the coordination of international or national law enforcement organizations to follow the money and develop evidence of corruption, the need to protect whistleblowers and encourage and protect investigative journalists, and to improve asset recovery. All of these things are valuable, but there's reason to be concerned. First, there were 40 nations at the summit, but they didn't include many of the nations who are regarded as the most corrupt in the world. In addition, it's not clear whether the pledges made by the 40 countries who were there will prove to be rhetoric or whether adequate efforts will be made to assure that they become reality. I said earlier that it's impossible to deal with the irreparable harms to human rights caused by grand corruption after the fact. Asset recovery is worthy. I support it, but it's not going to really deter the criminals who lead their countries and are so gravely abusing the human rights of their citizens. Secretary Kerry, in his opening remarks, talked about the tens of billions of dollars that had been looted from Nigeria in reference, and I think with pardonable pride, the $350 million the United States is seeking to have restored to Nigeria. I mean, as a judge, we believe in deterrence, but with the risk of returning a small percentage of stolen assets of a country really deter anybody. When I had the privilege of speaking before you in November of 2014, Arvind Ganesan from Human Rights Watch came and told the story of Teodoro Obiang of French Equatorial Guinea, who was both the vice president of the country and the son of the president. The Justice Department sought to recover $100 million from him in his Michael Jackson memorabilia, which was very precious to him. The case settled for $30 million, and he got to keep the crystal-studded glove somehow. Asset recovery is important. It's not sufficient, given the gravity of the offenses. Transparency of beneficial ownership is very important, and the improved ability to collect evidence of grant corruption is important too. But it's essential to recognize that those are not ends in themselves. If there's no place to use the evidence to prosecute cases and hold people accountable, it's really fairly futile. And the media in the last 10 days alone illustrates the challenge in many countries. And I'll pick two allies of the United States because they've been in the media. The New York Times on June 6th reports that a graph fighter in Egypt finds himself a defendant in court because a former judge who was made the anti-corruption czar in Egypt revealed that I think it was $72 billion had disappeared, and now he's being prosecuted for disturbing the peace. Or in Turkey, The Economist this week reports that there's a prosecution in New York of a gold trader for seeking to evade sanctions on Iran, in which he allegedly bribed ministers in Turkey, our ally. When these ministers were charged with taking bribes several years ago in Turkey, the prosecutor was removed. He's now being prosecuted for attempting a coup, and this trader and those ministers were cleared. But now we have sufficient evidence in the United States to show that, to indicate, to suggest that he shouldn't have been. This exists because the summit recognized the centrality of the UN Convention Against Corruption, the UNCAC. The UN Convention Against Corruption requires the 178 countries who were parties to it to have laws that criminalize bribery, extortion, misappropriation of national resources. The problem is, as Egypt and Turkey illustrate, they're not enforced. Transparency International studied this in 2013, and noted that the international community focused excessively on whether the statutes enacted are on the books and insufficiently on whether they're enforced. And that's what I've observed as well. The laws exist to hold high officials accountable. They're on the books in Russia, in China, and Nigeria, and every place else we might be interested in, but they're not enforced. And it's for that reason that I have, and not just I now, have advocated the creation of an international anti-corruption court, separate from but similar to the International Criminal Court, a court that would operate on the principle of complementarity. If a country which has these laws on its books is unwilling or unable to enforce them against its highest officials, they would be vulnerable to prosecution in the International Anti-Corruption Court. This, I submit, would be the quintessential innovative solution that the 40 countries at the summit dedicated themselves to exploring. This proposal, in the less than 2 years since I published my Brookings article and Washington Post piece, have generated a lot of support. This proposal is strongly supported by the United Nations High Commissioner for Human Rights, Prince Zaid Ra'ad Al Hussein, who completely recognizes that grand corruption and the worst violations of human rights are two sides of the same coin, crimes committed by the same people. Human Rights Watch I was really gratified to learn several years ago, very early into this recognition. And that is gratifying, and I look forward to strengthening our collaboration. I've had many good discussions with Global Witness, including in London next month. Global Parliamentarians Against Corruption supports this. Transparency International supports the International Anti-Corruption Court. Leading international prosecutors like Justice Richard Goldstone of South Africa, Luis Moreno Ocampo of Argentina, and Jose Ugaz of Peru are also supporters. And perhaps even more significantly, inspiring and courageous young people around the world support this concept. I was sitting next to a young man last night at dinner from Turkey who, after he heard about this for 1 minute, said, "We need this for Turkey. How can I help?" I have an email from him that came at 7 o'clock this morning. Sharon Asushi is here today from Kenya. She works with John Gathongo, who is an international hero in combating corruption. She wanted to get to Washington in time for this hearing, which is deeply, deeply gratifying. I've discussed this proposal around the world, and now, as I said, we're getting less lonely because an organization has been formed, Integrity Initiatives International, III, to institutionalize the campaign for the International Anti-Corruption Court, to support related measures, and to try to forge a network of networks of these young people who are dedicated to combating corruption in their own countries and in the world. We're in the process of planning a meeting at the Salzburg Global Seminar that will be keynoted by the United Nations High Commissioner for Human Rights, which will bring together senior statesmen, leaders of civil society, and younger people to discuss in depth the integral relationship between grand corruption, abuses of human rights, and this proposal for an international anti-corruption court, which I hope and trust will lead to a formal international campaign to create the court. So I commend you and the Lantos Human Rights Commission for continuing to focus on the relationship between grand corruption, abuses of human rights, and particularly the need to strengthen the capacity of the international community to prosecute and punish the perpetrators of both. In 2002, after a very long and arduous effort, the evils of genocide persuaded the international community to create the International Criminal Court. I submit that it's now time to recognize that the comparable consequences of grand corruption justify and indeed necessitate the creation of an international anti-corruption court. Thank you very much.
Well, thank you, and I certainly support the creation of an international anti-corruption court. The challenges that we have to try to figure out is how do you get there? As we're trying to get there, what are the steps we need to do in the meantime to get at as much of this corruption as possible? Now, this may be an unfair observation. This is just my experience. As someone who's been in Congress for 20 years, who served as an aide on the Hill for years before that, but my impression of a lot of our anti-corruption efforts here in the United States with regard to other countries, it always seems to me that we're more focused on petty corruption than on grand corruption. And without getting into naming by name the countries that I'm thinking of when I'm saying that, I've been to a lot of places where, we've been told that this mid-level person, is engaged in practices that, we're going to go after him or her, or this, this group or this one individual. But in those same countries, we also know that the president of those countries are, basically the king of corruption, and yet we don't seem to want to, rock the boat. And it seems to me that, that there needs to be a greater emphasis, kind of on the issue of grand corruption, and a better coordination within various administrations, because to get at this, it's not just State Department, it's Treasury Department, it's Justice Department. Maybe Homeland Security. There's all kinds of, and I sometimes wonder whether there is a group that kind of sits around, interagency group that just deals with these issues of corruption. Am I characterizing our role in this unfairly? Anybody who wants to, since the State Department's not here, we can say whatever we want. Ms. Ostfeld?
I think you're absolutely right. It's a question of political will and how rare it is to go after a head of state, or how we don't do that until that head of state is on his way out. For example, with Libya during the Arab Spring, we had published documentation of where the Libyan Investment Authority kept its money.
Right.
There were banks in the United States, there were banks throughout Europe. As the Arab Spring was happening, all of a sudden the banks were freezing all of that money because they recognized that some of it was corrupt and for other reasons. But why was it there in the first place?
Right.
Like, why aren't we stopping it from getting into our banks in the first place? We wait until, high-level politicians are on their way out to actually do something. So I think you're absolutely right.
Part of the reason I think they're inactive on heads of state and senior officials at that level is they're scared. They're scared of instability. It's true that corruption is a national security issue. The Shah of Iran fell because he was corrupt. The Muslim Brotherhood has had certain members in the 80s who became hyper-radicalized and ended up helping start Al-Qaeda because they were fighting against corruption in Egypt. And Tunisia started the whole Arab Spring because it was prefaced by the exposure of corruption, which the U.S. knew about. And the bigger picture, I think, is that governments around the world are getting torn in different, more drastically reactionary or hyper-progressive directions because electorates, where they exist, have an appetite for the far left and the far right. So this polarization is happening because of corruption. And that emphasizes why the stakes are so high, but it also explains why the State Department and the White House is often so afraid to tackle these issues, because when you get into these issues, you're talking about things that make governments fall. And governments falling scares the hell out of them.
Well,
But yeah, you have to do it. You have to fight these things. You have to. And so the key, what I was going to recommend is that what they ought to do is explore the tools that are at their disposal and use them where they can. And I'm very thankful that my colleague from Global Witness mentioned the Global Magnitsky Law, because it needs to be passed. This would be a vital tool, as one example.
Judge?
I think there are some limits to what the United States can do alone, but I'm hopeful that the equation is changing. I agree with there must be a whole array of considerations that go into deciding which leaders will support and how much corruption the United States will tolerate, even though we know those leaders are not behaving in a way consistent with our ideals and universal ideals concerning human rights and corruption. But I think the reason that the proposal for an international anti-corruption court has got so much attention is that leaders and others around the world, including Secretary Kerry, I'm confident, see that indignation at corruption is destabilizing our allies, among others, Egypt, Nigeria, Ukraine, and then in the process, creating grave dangers for international peace and security. It's those grave dangers that provide, I mean, that's the purpose of the United Nations, to deal with threats to international peace and security. But now I think the strategic calculation is changing, or at least certainly should be. And I've read and heard Secretary Kerry talk about this. If you look at Nigeria, for example, and he's discussed it, the constituency for Boko Haram initially was largely people who were indignant about the corruption in the capital and wrapping it in religious rhetoric. Boko Haram was the institution that opposed high-level corruption. We, understandably, I'm sure, would rather not have American troops in Nigeria fighting Boko Haram. You'd like to strengthen the Nigerian military. But under the previous president, Goodluck Jonathan, and Secretary Kerry talked about this at the summit, if you gave money to Nigeria, only a tiny fraction of it ever would have got to the military. So now I think we're in a situation where the United States and other countries have the opportunity to recognize that opposing grand corruption, giving higher priority to protecting human rights is also in the interest of national and international security. And it's this confluence of events that I hope can be capitalized on.
So, you know, as the primary author of the Magnitsky Act, which was originally global when we first introduced it, but then we had to narrow it down because for some reason global costs more money. And we're moving hopefully forward with a global Magnitsky bill. The Senate is going to maybe attach it to the defense bill. If not, we can hopefully get them passed in both chambers and be able to reconcile any differences. But the reason why we did it was not because any administration didn't have the tools to do everything that was in the Magnitsky Act. Any administration, you know, could have publicly shamed people guilty of human rights violations and corruption. They could have frozen their assets in the United States. They could deny them entry to the United States. They could have done all those things. But the fact was that nobody was doing it. And so we did the Magnitsky Act kind of to force people's hands. And I think it's been an important tool because we know who some of the really bad players are. And we know a lot about their corrupt activities. And, you know, and yes, we can expose them, but there is no consequence in Russia, for example, for those actions. So therefore, the consequence is, you know, you can't have your money in U.S. banks. You can't come here and go to Disney World, and you are on one of these lists. So there's a shaming process, and I think that you know that's better than nothing. And hopefully it is a signal to others that there is a consequence. That we do the global Magnitsky, and if we're consistent in its application, you know, that people who are guilty of corruption, you know, at all levels will realize that there is a consequence, because I think that's part of the challenge is there has to be a consequence.
May I just add to that? One of the interesting things about the strategy that the State Department and Treasury and White House can engage with that bill is that you don't necessarily need to target the head of state.
Right.
You can be very strategic and target very powerful ministers within a government. Like
Or wealthy friends of the heads of state.
And gently create a situation that makes it more likely that there will have to be change at the leadership level. I'm thinking, for instance, of Cambodia, where targeted sanctions directed at senior leaders under Hun Sen would perhaps lead them to reevaluate whether Hun Sen is the best leader for Cambodia and push him to hold free and fair elections as opposed to stealing elections like he does every 5 years for the last 25 years.
Mr. Chairman, we've been talking about what the executive branch can do.
Right.
I think there should be at least equal attention with regard to whether how Congress is doing in this area. The United States, I think, can be very proud of its history with regard to combating international corruption in many respects. I mean, it was Watergate that spawned the Foreign Corrupt Practices Act. So what's Watergate, which is where I came in as an assistant to the Attorney General of the United States. After Watergate, we're holding the President of the United States accountable. He wasn't prosecuted, but people around him were, and there was a political solution, as you're describing. And because in the United States, corporate law historically has been state law, not federal law, we don't have a good record because of some states on the transparency of beneficial ownership. Right the week before the summit, the president sent proposed legislation to the Congress that would, if enacted, as I understand it, preempt state laws and greatly improve the transparency of beneficial ownership in the United States. In the process, that should make the United States less attractive for looted money because there will be risks of prosecution here for money laundering or other offenses. But I haven't read that proposed legislation has obtained any traction or very many ardent supporters in Congress. So I think in our system of separation of powers, it's valuable, very valuable for members of Congress like you to seek to hold the executive branch accountable to see if it's doing as well as it should be doing. And on the other hand, Congress should also be accountable to and be evaluated on whether it's acting in the very best interests of the United States and enacting legislation that'll give integrity to some of our highest ideals.
Well, I think that's a good point, and Ms. Ostfeld mentioned a couple of pieces of legislation that we should pass, and I think we all. Am I fair to say that everybody thinks that if we could have an international anti-corruption court, that would be a good thing? Yeah. So, assuming that that's kind of the ultimate, goal, we want to go, recognizing the difficulties involved and time required to develop, new kind of treaties or, agreements like that. It's important to kind of focus on those interim steps of what it is that we can do. And I guess, the question is, how do we kind of, what are those interim steps?
Well, actually, if I may,
yeah.
because it may not have been clear enough in my remarks. One thing we could do is seek a coalition to seek strengthening of the monitoring of the UN Convention Against Corruption. The UN Convention Against Corruption has 178 parties. They've all pledged to enact, and almost all have enacted, laws making bribery and extortion, money laundering illegal, even by their highest officials. The monitoring system was originally designed to be very weak, and it is very weak. And I testified about this to the UNCAC Implementation Review Group a year ago. I mean, for example, the UNCAC monitors can't go into a country to ask questions unless they're permitted, and their reports are not publicly available. Two small examples of the weakness. So that's on the books. Under international law, the United Nations Treaty on Conventions, as well as the UNCAC itself, every one of those 178 countries has pledged to make a good faith effort to implement those statutes, to enforce them. But the international community, and perhaps including the United States, has not sought to have them enforced. If that was a successful effort, and every country was enforcing the statutes on its books in an honest, impartial way, as we, I think, can be proud of doing in the United States, not perfectly, but well, there would be no need for an international anti-corruption court. But some insistence that the pledges 178 countries have made be honored would be a very important next step.
Sorry.
Chairman, if I may, I just, in countries where corruption is endemic, it can affect virtually every dimension of life, including going to a doctor, getting an operation, getting into a school, getting a driver's license, registering a business. And so in those cultures, there is a need for a systemic strategy to counter a systemic problem. And there's a need, there's been a lot of good research that's been done on how to have such a systemic strategy. You need a compact as between the local civil society and government and the international community. So I think it's important to keep the international community in mind here. These are both corruption and human rights are understood to be transnational and domestic phenomenon that need enforcement internationally and locally. So as I indicated in my remarks in my statement, I think it's time from an international perspective to re-examine the whole question of whether fighting corruption should be treated simply as a means of protecting other human rights. And there's plenty of precedent for this.
And how do we do that?
Well, first of all, I mean, as a conceptual matter, there is a whole school of thought around creating a new human rights, which is called indivisibility. And the thrust of it is that you cannot really uphold or protect one human right without getting all the others right at the same time. And so what I have experienced in my work in the public sector, in the private sector, in the nonprofit sector, is that there is a growing awareness in the world, in all the countries that have been mentioned here, among civil society leaders, that they should have an expectation of a better life in which they have the right to expect that governments won't steal from them, that they won't be extorted, that they can be empowered and economically able to get a business started. And so, where we get started is with maybe all good practical and legal results start with a good idea and a good theory. So it may be that globalization compels us to think this whole international architecture through again at this time. That's the essence of what I'm suggesting. As a practical matter, I am myself now just thinking about what a good strategy would be for engaging international civil society, the international legal community, all the multilateral bodies that are interested in this. And so I don't have a specific recommendation, but I can tell you this: there is huge interest.
Well,
Huge interest.
And we'd be interested in as you come to some, recommendations about, concrete steps. And I agree with Judge Wolf. I mean, look, I would like the international mechanisms to work better, and I'd like all the mechanisms within the UN to do what they're supposed to do. But sometimes it's a little bit of a challenge, and it's not just on the issues of corruption; it's the issues on human rights in general. So again, I mean, if there are suggestions of kind of concrete steps that members of this commission can take to urge some of the, I'm assuming, some of the highest levels of the United Nations to, that this is something that we're going to be focused more attention on and would like to engage them more, if that's helpful, I think that's something we'd be interested in doing.
Well, I actually, your mention of the United Nations suggests something that you might do and that we might join you in doing. A new Secretary General will be selected soon. There are a number of candidates reportedly from around the world. I think that an effort should be made to get these issues we've been discussing. Under your leadership, how will the United Nations deal with grand corruption, the kleptocrats who also abuse the human rights of their citizens, give integrity, require that integrity be given to the pledges made under the UN Convention Against Corruption, and what's your position on the International Anti-Corruption Court if countries' leaders are not living up to those obligations?
That's a good point. Ms. Ostfeld, I knew you had something to say. Before you say, I just want to tell you that I thought, again, that 60 Minutes piece was quite revealing. Sometimes I kind of feel that nothing shocks me anymore because, everything that's going on. But that was shocking. And maybe technically nobody violated the law, but there is something that was that was troublesome to me, that these attorneys that were being approached weren't saying this is illegal. Our legal advice is this is illegal. This is not something you should do. And these weren't, ragtag attorneys, from what I understood from the 60 Minutes piece. And again, I'm not an attorney, but I do know there's codes of ethics, and I do know, the American Bar Association, talks about some of these issues, but it was also troublesome because it made us complicit in that corruption. So it's not just something that's happening overseas. We're allowing it to happen here. But I thank you and Global Witness for doing that. But anyway.
Thank you, Mr. Chairman. That's fantastic to hear, because that was the entire intent. There's case after case of this kind of thing happening. There are all of these studies that show it, but nothing pictures it, that you can't actually wrap your head around what this looks like. So that's why we wanted to make it visual. And it's based off of real cases.
Right.
I mean, that's how we designed it. If you look at the Obiang case that was brought up, it is very similar to the ways in which he brought money into the United States. It's quite parallel, even though no money exchanged hands in the 60 Minutes example. But I wanted to go back to your other question, which was, what else can we be doing?
Right.
And so Global Witness is very focused on the prevention side, because it is so hard to prosecute, as we've been talking about, and so hard to return stolen assets that statistics show it's less than 5% of money stolen is ever returned. So this is incredibly low. So we focus a lot on prevention. And so part of that is requiring, companies, specifically in oil, gas, mining, to publish what they pay to governments, because that's the only way citizens in those countries can understand what should be coming into the Treasury in order to hold their governments accountable. And the SEC is going to issue a final rule requiring U.S.-listed companies to do just that. We believe imminently. We hope imminently. It's been a long process. And we need to stop, rolling out the red carpet to the corrupt. I mean, that's the other piece of it, that there's a lot that we can be doing here. The Towers of Secrecy series in the New York Times last year really shined a light on how dirty money is ending up in the Manhattan property market.
Right.
As long as we're willing to take it, and we are, because we want the money, that's why we haven't made these changes, this kind of behavior is still going to happen. But specifically on real estate, Congress has actually already spoken. Congress has already said that the real estate sector should be regulated with money laundering obligations since the Patriot Act.
Right.
But they gave Treasury a temporary exemption in order to figure out how to do it. So that was in 2002. There's been this temporary exemption since then, and very, very little has happened. So Treasury could be pushed to actually issue a rule to start regulating the real estate sector or parts of the real estate sector. What happened after the New York Times series is Treasury started to look at it a bit more and issued a temporary, what's called a geographic targeting order, looking at Manhattan and Miami and property over a specific amount. But it is very small and focused on title insurance companies. which is important, but if I'm a corrupt dictator and I'm putting millions of dollars into property because I want to get it out of my country into another location, I don't need title insurance. I don't need a mortgage. So it's a piece of the problem, and it's something that Treasury could do now, and Congress could pressure them to do it. As far as the beneficial ownership bill, I mean, what we have seen is that it is the easiest way to move money, if you want to do it quietly, is set up a company and hide the fact that you own it, and that the largest problem is here. And so while it's fantastic that the administration has put out a new proposal, it's also important to know that there's current legislation that is bipartisan that's actually very similar. What the legislation does, the Incorporation, Transparency, and Law Enforcement Assistance Act, is require Treasury to collect beneficial ownership information from American companies with a number of exemptions when they're incorporated, unless the states are already doing so. So it enables the states to decide if they want to update their process in order to collect this information, since that's where incorporation lies, and if they don't, Treasury is a backstop.
And that's the Peter King, Cal Maloney bill?
Yes.
Okay.
Which has a companion in the Senate that is also bipartisan.
Thank you.
No, I was going to just finish. I have something to add on that bill, but go ahead. If you're
And the other piece is visa bans that go along with the
Right.
real estate, which is clearly part of Magnitsky. And
Right.
bringing all of that together to make it a lot harder to move your money deters some of it in the first place, because when you're talking about grand corruption, they want to spend it in some other place. They want their kids to go to school here and in
Right.
London and in Paris. And to make it harder to do that makes it hard. And if you can't move the money, nobody wants to keep all of the money inside their country.
The legislation on beneficiary transparency is very important. It may sound a little boring, and nobody likes talking about Delaware's corporate laws, but it's a very important piece of legislation, and it goes to the heart of what was being discussed in London. And that just leads me to a side corollary of that, which is that the United States government is not going to be able to convince other governments to make improvements in their regimes if it can't show that it's making improvements to its regime. It's very difficult to talk to David Cameron about the massive amount of tax havens that exist under British jurisdiction if you, as a U.S. government official, haven't been showing that your government is taking its efforts here with Delaware and Wyoming and other states like that. They've got their British Virgin Islands, we've got our Delaware. We have to do each. And one thing that Congress can do is members of Congress can meet and discuss the common ground with members of Parliament in London who are addressing the same issues. They're very different issues, but they can bind together in working to change the laws on the books there, but also pressure their own leaders. And that brings me to the last thing, which is a lot of the stuff that needs to happen also is just about the executive being a good executive. And members of Congress can do a whole lot just by urging the executive, the next president, whoever she or he is, to better coordinate the National Security Council staff. There's an atrocity prevention board. There's somebody, it's not, I mean, there's legislation to create it, but it's really just the executive operating on their own to coordinate the interagency process to deal with things. Why not have a National Security Council staff or director who is, very much working to coordinate anti-corruption better than they do right now?
That person exists now. I've worked with her, and she's dedicated. All of these measures, and the president, when he sent up his proposed legislation, also strengthened the Treasury regulations that relate to disclosure of beneficial ownership. So some things have been done, but I think that while it's true people would rather own property in New York or Palm Springs, there are many other attractive places around the world, and that increased transparency of beneficial ownership, I reiterate, in my view, is not an end in itself. We wouldn't want to live in the United States in a system where we relied on civil remedies like asset recovery or civil lawsuits to deter corruption or indeed any kind of crime, bank robbery. I mean, a fundamental premise in our country of the criminal law is that the laws are on the books. They make a threat. They threaten that if you violate those laws by robbing a bank or a public official taking a bribe, that there will be consequences, and that it would be a miscalculation to think that it's worth it. And there is a gaping hole, in my view, in the international system, because that fundamental premise of the criminal law in the United States and the UK generally, it doesn't exist with regard to high-level corrupt public officials. And all these other measures are important. More transparency of beneficial ownership and improved ability to investigate the flow of corruptly obtained money would be essential to the efficacy of an international anti-corruption court. But I reiterate, if we know who owns the property, but maybe now some of it's in Panama or some lovely Caribbean island, not in Palm Springs. And if we have the evidence, you're not going to turn it over to the courts in Panama, because somebody who violated the Panama money laundering laws is not going to be effectively prosecuted in Panama. And if that money came from Malaysia, has been mentioned, you're not going to give it back, the evidence back to Malaysia. When the $682 million was found in the Prime Minister's account, his chief prosecutor cleared him of any wrongdoing. The Swiss are investigating. They're not convinced that laws weren't broken, but their investigation is frustrated because they can't get cooperation in Malaysia. So improved law enforcement investigations are important, but ultimately you need someplace where the evidence can go and where people recognize that there's a serious risk, not that they'll just have to give back a fraction of what they've stolen, but that they'll go to prison, and then hopefully they will behave differently, and by not stealing these funds, also not deprive their citizens of their most vital human rights.
Right. You know, just one other issue, then I'll just ask you guys for closing comments of things that you want to get on the record that I didn't ask. But the other issue that I keep on thinking about that's essential here is the issue of protection. I mean, you know, I mentioned the Sergei Magnitsky Act. I mean, this was a guy who was a whistleblower in Russia and who basically was killed in prison for being outspoken on some of the worst corruption in Russia's history. Just like human rights defenders all around the world who dare to raise an issue that's uncomfortable for the powers that be, you know, and they get threatened. I mean, the same thing happens here. And sometimes, you know, some of these powerful people take it even more seriously because it goes at their pocketbook, and they can't ignore it. And so I'm just trying to figure out whether anyone has any recommendations on having to do with protection, you know, how we can beef up protections for people who expose corruption. Because what we have seen is that there's a lot of history here where people end up dead or in prison, and or they're defamed or whatever. And, you know, and I don't know whether anyone has any ideas about that.
One thing I would say is that the State Department has done amazing work over the years protecting civil society members and human rights defenders who come under threat. But to be perfectly frank, their efforts are always a little bit ad hoc. And it would be good to actually, I don't think it's worth a hearing, but it would be good to really lay into state a little bit more about systematizing the way they deal with protection of human rights defenders overseas. Because it's very ad hoc, it's very personality-based, case-based, ambassador sort of style of business-based, and that should change. I think they need to really systematize it a lot more. You're absolutely. By the way, Malaysia, the person who leaked the information to Sarawak Report and ended up in the Wall Street Journal that exposed Najib's corruption is dead. I can't say why he died. I'm not saying Najib killed him. I can't say that. That would be defamatory. But these are very real issues that need to be addressed in all of these.
And we're seeing that all around the world. I mean, even in Honduras, you're getting people who are labeled as human rights defenders, but who are also exposing corruption, and they're ending up dead. I mean, it's just it's happening, and I think we need to also figure out, if we're going to encourage people to expose this and to talk to reporters, or to, until we get a system in place where we can hold people accountable, there needs to be something, where we can guarantee the safety of people who come forward with this information.
But I think it requires a different paradigm. I, of course, have dealt with many people who ended up in the witness protection program,
Right.
because, as you know, I've had, in the past more than 25 years, major mafia cases and other organized crimes cases, including one involving James Whitey Bulger, who was murdering people that the FBI told him were informing against him. I found that. It's been proven beyond a reasonable doubt in trials. But there, we recognize and describe the people who were threatening to the witnesses as criminals. Here we're talking politely about the prime minister of this and the president of that. If they are killing or menacing people who are exercising their right to free speech, universal right to free speech, and exposing corruption, they're criminals. And they shouldn't be treated as honored members of the international community at summits or elsewhere. They can do this with impunity because they're not treated the way we treat criminals in the United States, and the way people conventionally regarded as criminals are treated in almost all countries. Right. So there's something of a paradigm shift, perhaps, that's required here. But again, it's bringing the criminal law in some fashion to bear, and part of it is not semantic but rhetorical, in saying that we have a criminal investigation. If what Mr. Sifton described happened in one of my organized crime cases, somebody gives the FBI information about a member of La Cosa Nostra, and then that person dies under suspicious circumstances, there's a major criminal investigation by an independent, impartial body, and there's a place to bring the evidence. And even if it's a high-level mafioso, the investigation and the prosecution are conducted. But if the same conduct is engaged in by a prime minister of a country, we are now somewhat in a situation of saying, what can we do? And Malaysia is a party to the UN Convention Against Corruption. It's made a pledge, and I don't really see the international community putting pressure on Malaysia to live up to its obligations to conduct investigations when there's good reason to.
Right. But until we get that
investigate.
international mechanism in place, kind of our experience has been, you call a lot of attention to the person who had the courage to come forward, and you give them that circle
That's
of protection, whatever we, and certainly at the highest levels of our government, even mentioning some of these human rights defenders by name, may not guarantee that they don't go to prison, but probably might guarantee that they don't get killed.
Yeah.
And so we need to think about ways that we can, I think better provide that protection to human rights defenders and whistleblowers on issues of corruption. So let me begin with any final words, any concrete additional recommendations that you think this commission should undertake, and we can, whatever I didn't ask that you think is important to get on the record, I would yield to you. And okay.
Real quick, I think the last point is a very important one, and members of Congress and the executive, whoever the executive is, and the State Department, Treasury Secretary, anybody meeting with civil society, gives them a measure of protection that may very well keep them alive. So that's one thing. And then the second thing is, Human Rights Watch publishes every year, as you know, the World Report, which is about 90 different countries. The State Department publishes its human rights reporting. One other thing that hasn't been discussed, if we are going to make corruption into a human rights issue of its own and not just something that drives other human rights abuses, it might behoove Congress to consider compelling the State Department to write about corruption the same way it writes about human rights.
That's something we can actually do from here, so thank you. Ms. Ostfeld?
Thank you, Mr. Chairman, and especially for mentioning Berta Caceres from Honduras, that we had worked with her
Incredible woman.
in the past, that we put out a report each year, which we talk about environmental defenders who've been murdered. For the last 4 years, we've put out this report, and by environmental defenders, we mean people trying to protect their land and their livelihoods. And last year, in April, we actually launched it with Berta here in DC on the panel. And on Monday, we will be releasing our report for 2015, which is actually going to show that numbers have increased. So if it is okay, I would submit it for the record,
Absolutely,
although it's
without
embargoed
objection.
until Monday, but that the U.S. in particular could use its influence to make sure there are independent prosecutions in these cases. That Berta has gotten a lot of attention, but there are hundreds more where their names are not known and nothing is happening. Somebody else from her organization was also murdered, and there is no investigation there. So thank you.
Sorry.
Congressman, I close by saying first, thank you very much for your leadership on this issue and for entertaining all ideas, including, as Judge Wolf has suggested, the need to think about whether we are in the midst of a paradigm shift. And I think we are. So whether as a political leader or as thought leaders or civil society leaders, I think there is abundant evidence now that you cannot simultaneously maintain these legal commitments, obligations, and with public awareness rising, not meet them.
Right.
So this is all good. And so back to the thesis that I presented today, there are cultures of impunity where there's a certain level of corruption that may be tolerated, and that happens at an official level. It also is endemic in this civil society and the cultures where it takes place. So the advantage of the rights paradigm that I put forward is it could over time shift expectations of citizens so that they come to have higher expectations and want to hold government officials accountable not only for their corrupt acts, but also for the delivery of good, efficient, honest public services on a day-to-day basis. And so there's an affirmative aspect of all of this, which is another way of saying that there's a freedom from corruption that exists out there as a human right is to say there's a right to honest government service that could be deemed to be universal. And this is an area that's controversial within the law, within the bar, internationally and domestically, but it's always, I think, important to think about this in the affirmative.
Right.
What can be done to build civil society and strengthen their expectations that they deserve to get honest public services on a day-to-day basis? Because the less tolerance they have, the more unlikely it is that kleptocracy can be done with impunity.
Thank you. Judge?
I, too, would like to thank you again for convening this hearing. I thank Human Rights Watch for reiterating its endorsement of the International Anti-Corruption Court. I thank Global Witness for its endorsement, and I particularly thank you for your dedication to these issues. You said a number of things that recognize or perhaps emanate from the many battles, worthy battles you fought and not yet won. And one could, it is correct to say that the effort to establish accountability under the criminal law through the International Anti-Corruption Court particularly, at best is a long one, an uncertain one, but I'm one of the older people in the room. I've seen seemingly unimaginable things happen and happen really rather quickly. The fall of apartheid in South Africa, the collapse of the Soviet Union. Louis Brandeis said something, my judicial hero said something very similar to what Mandela said. It always seems impossible until it happens. But even recognizing that some of the things that we're discussing, striving for, might never be achieved, there are young people around the world who do not accept corruption generally, or grand corruption particularly, as an inevitable way of life, the way perhaps their parents did. There are people like Sharon and John Thongo, for whom she works, with whom she works, who are risking their lives in Kenya to have more honest government that will also provide greater security against al-Shabaab and others. And at a minimum, whether we win or lose, to be colloquial, we owe it to them to have leadership in this country that makes its best effort to combat corruption and to promote human rights. You're a leader in that. I am confident that this quest is becoming much less lonely, and I look forward to continuing on this path with you and many others.
Well, good. Thank you. I want to thank you all for your excellent testimony, and there's a lot of follow-up that I think this commission has to do after listening to all of you here today. I support the goal of an international anti-corruption court. I think that I would urge you to stay in touch with the commission. If there are ideas that you come up with in the coming weeks and months that you think we could follow up on, we would like to do that. The other thing is, we will have a new administration. And so maybe this group or a few others in addition to you, maybe we can help facilitate a conversation with the next administration about how do we get this issue, make sure it stays front and center, and it would maybe have to be an interagency meeting. In any event, I appreciate you being here, and have a good weekend. Thank you. Hearing is adjourned.